All right. All right, everyone. Today is January the 22nd, 2021. This is Top Quality Recruitment versus Inland Fresh Seafood Corporation of America, Inc. And this is 2017 CV295535. I'd first like to begin by addressing everyone's appearance today. As it turns out, we are all appearing via the Zoom teleconference platform. However, I do want to point out that I'm sorry, but defendant's counsel and defendant.
This is our co-counsel, Paul Oliver.
Oh,
Good morning, Judge.
Okay, good morning.
Sorry.
All right, so your client is not there.
No.
Okay, I misunderstood you. So unfortunately, and the defendant's counsel are present in courtroom 8A. I am remote. Plaintiff's counsel is appearing via the Zoom teleconference platform, and we are here. And I want to also add that we are live streaming these proceedings on the court's YouTube channel, which ensures that the public retains access to its business during this pandemic. So as soon as the proceedings are over, I will turn the live stream off, and it should not be preserved, but it is accessible while it's going on. So we are appearing today, or we're on the calendar today for a hearing on the plaintiff's motion for attorney's fees and expenses pursuant to 9-15-14. If there's no other preliminary matters, I will turn these proceedings over to Mr. Kaufman.
Judge, good morning. Alex Kaufman here for the Plaintiff Top Quality Recruitment, Inc. I don't believe there are any other preliminary matters. With that, I'll address the 9-15-14 motion that is before the court today. Obviously, this case has got a lot of history. In fact, it's way too much history for a $20,000 dispute that never should have been. This case was filed on September 18th, 2017. With petitioner's verified complaint for breach of contract, or in the alternative, quantum merit and unjust enrichment. The contract was very simple. The Top Quality would do work to make a placement, and if that placement, that candidate was hired within 12 months of being introduced, they were owed 20% of the first year's salary. What's worse is that Inland Fresh Seafood knew about the contract and intentionally decided to disavow it and hired the placed individual anyway. And what's significant also is that opposing counsel's co-counsel was actually a officer and very much involved in the business operations of the business per Jerry Staines. In fact, he was an officer. So then when we look at the standard of 9-15-14, part of it is if there was just undue delay or any absence of any justifiable issue of law that could not be reasonably believed that a court would accept the asserted claim, defense, or other position, and that's under 9-15-14A, citing Haney versus Camp at 320 GA App 111/2013. And that is a shall, if the court finds that the court shall award the fees. And then there's the may provision under 9-15-14B, if any, if either counsel or the party finds, if the court finds that counsel or the party brought or defended an action or any part thereof that lacks substantial justification, or that the action or any part thereof was interposed for delay or harassment, or if it finds that an attorney or party unnecessarily expanded the proceeding by other improper conduct, including but not limited to abuses of discovery procedures. Lacks substantial justification means substantially frivolous, substantially groundless, or substantially vexatious. And that's under 915.14b, and also the Haney case, as well as Wall v. Thurman, 283, Georgia 533, 2008. So then when we look at the history of this case, we don't have to go any further than the verified answer, which had 18 affirmative defenses, most of which were completely and totally unjustifiable, including plaintiff's claims are barred by the doctrine of unclean hands. Plaintiff's claims are barred by illegality. Plaintiff's claims are barred by a failure to perform conditions preceded necessary for enforcement of the contract. Plaintiff's claims are barred due to accord and satisfaction. Plaintiff's claims must be dismissed because of insufficiency of process. Plaintiff's claims must be dismissed because of insufficiency of service of process, and many others. And then, of course, we go to remembering the history of this case in October of 2018, where the court ordered and granted our motion to compel discovery because they had played games and prevented access to personnel files, prevented access to emails, and in fact had even spoliated emails, which included our motion for other discovery abuses. And in that motion, the court reserved, and you wrote, all fees requested in plaintiff's motion to compel are reserved. And they were reserved for today, which is why we have our 9/15/14 hearing. And the court granted our motion to compel the discovery. And let's not forget also, then the court, upon defense's motion, begged the court to reopen discovery, and we had to then take an unnecessary trip to Pennsylvania to take depositions that had absolutely no value to the case, as the case was already granted summary judgment right on the clear and unambiguous facts of this case, which caused my client to incur substantial expense for that travel. And then let's look back on the December 10th motion for sanctions and spoliation of evidence, which we filed, which we never actually had a hearing on because the court opted to grant our motion for summary judgment in February of 2019, and which we appreciate. And the court's findings of facts and conclusions of law were clear and unambiguous and correct. In fact, the court said, quote, Mr. Domina executed the agreement in his capacity as Inland's general manager of operations on August 23rd, 2016. And the court found that we submitted the resume and they were hired. And we met all the legal standards, which the court addressed under 91156C. Then defendants decided to appeal the case to the Georgia Court of Appeals, which they lost, and then appealed again to the Georgia Supreme Court, which did not accept the case and went back. So this is probably the most over-litigated case for $20,000 possibly ever. But then when we go back to the law, we've touched on 9/15/14 A and B, but this case, Graves versus D'Ambrose, which is found at 243 Georgia App 802 and 534 Southeast 2nd 490 2000, is particularly useful. In fact, it reads, the court goes on to clarify that the focus of this provision, citing the 9/15/14 provision, is likewise upon the actions that may be undertaken in connection with the underlying legal proceeding, and not upon any pre-litigation actions of one who eventually becomes a party to a civil action. We agree. We're talking only about once this action had began. But the court continues, as to whether the defendant was stubbornly litigious or caused the plaintiff unnecessary trouble and expense, so as to warrant award of attorney fees, mere refusal to pay a disputed claim without suit is not sufficient to award attorney fees. The key, and this is what's important, Judge, is to test whether there is bona fide controversy, and where none exists, forcing a plaintiff to resort to the courts in order to collect is plainly causing him to go to unnecessary trouble and expense. And that's exactly what happened here. There was no dispute that Top Quality made the placement. There was no dispute that it was a valid binding contract. This was not some attempt to create new law here. Their facts were clear and unambiguous. And in fact, if we look at the Cobb County versus Savannah case, it says, defendant advanced frivolous factual and legal arguments in superior court, and these arguments were dealt with the court on summary judgment. And in fact, summary judgment in the grant of, although it is not dispositive that fees should be awarded, is incredibly illuminating and gives great deference based upon Georgia case law and precedent. And in fact, in that case, it wrote, it is proper for this court to award attorney's fees accrued after the filing of the complaint under OCGA 915-14, which is exactly what we've asked for. And that amount is $46,828.26, which is in the proposed order, which I provided to the court. I believe I filed that in October. So we believe that those fees are just and necessary. I stand in my place. I filed 2 affidavits with those fees. At all times, I was the partner in charge. I worked elbow to elbow, shoulder to shoulder with all the attorneys that were under me. I am familiar with the billing practices of both Kaufman and Foreman and Fox Rothschild. I personally reviewed each and every one of those bills before they were submitted to the client. And I was the corporate secretary of Kaufman and Foreman and the custodian of the law firm's records. So I'm not quite sure why we see so much emphasis on the defense saying that these are summaries, because they're not summaries. We have met the 8036 business records exemptions. These are actual records. They're not a summation thereof. And these were the records and the official records of both law firms and those that were provided to the client for remittance of payment. My education is as a graduate of Westminster Schools here in Atlanta, Hamilton College, and Emory Law School. I'm a member of 5 state bars: the State Bar of Georgia, New York, DC, Massachusetts, and Arizona. I've been a partner at level lawyer for over 6 years now. My rates are commensurate with those in the metropolitan Atlanta area. And I stand in my place to answer any questions concerning the billing practices or the veracity of those bills. If and so the court or opposing counsel needs to address that. But we believe that it would be right for the court to grant both under 915-14A and 915-14B, because there was a complete absence of any justiciable issue of law or fact that no court could reasonably believe would be accepted. And then also this court, with its discretionary power under 915-14B, may, and it should, grant attorney's fees and expenses that were incurred, which are about 2.5 times what the underlying fact was. We have done our best to have this case resolved. I had a pretty good negotiations professor and certainly used my best efforts in education to that expense and attempt, but it failed. But the only reason this case did not settle, in my view, is that they were claims and defenses that were expanded and with lacked legal merit. The purpose was to delay and to harass, and this court could find that attorney or party unnecessarily expanded the proceeding by other improper conduct and discovery abuses, which the court did grant our motion to compel. And we did incur the additional expense when defense counsel asked to have the matter reopened, and incurred substantial travel to Pennsylvania, because in fact, the purpose was to take depositions of the individual whose emails had been destroyed. And that's why that was the next, instead of using the best evidence of the emails, we had to travel there. Of course, they were on notice that there was a lawsuit pending, yet they destroyed the emails anyway, and hence the spoliation motion that had not been heard. This motion was made under 915-14 orally. And again, it was made within 45 days of the remitter, so it is timely pursuant to 915-14E. With that, I will yield to the court and opposing counsel.
Mr. Kaufman, let me just ask you, but for the 915-14, is there anything in the contract itself that deals with the question of attorney's fees?
No, ma'am, there is not. These are Canadians. They had drafted the contract for there. It has now since been remitted, but as the contract had issued, it was not.
Okay. And I am, just to let you know, if there is any examination that the wish to make, just y'all excuse me one second. If there is any examination that the defendants wish to pursue of your testimony, of your fees, I will allow that. Okay, I'll turn it over to the defendants.
Good morning, Judge. Inland is requesting that this court deny the plaintiff's motion for sanctions under 915.14 for two reasons. Specifically, the plaintiff has not set forth any facts upon which sanctions under 915.14 can be based. Second, Inland did nothing in litigation to warrant fees under OCGA section 915.14. Finally, Judge, if this court is considering granting their motion, we request an evidentiary hearing where we can really get into the reasonableness and necessity of each of the time entries. And we also request an order to give us the opportunity 30 days prior to that hearing to review the original written records, billing records of the plaintiff, because what they have submitted is just a summary. First off, the plaintiff has not set forth any facts upon which OCGA section 915.14 sanctions can be based. OCGA section 915.14 sanctions conduct occurring during litigation. It cannot be used to sanction conduct occurring prior to filing the lawsuit. However, that is what the plaintiff has done in its motion. The plaintiff is basing its motion on conduct that occurred prior to initiating the litigation. When you read the motion, it talks about how the parties entered into a contract on August 23rd, 2016. It talks about how Inland hired the referral employee on February of 2017. And then eventually how Inland refused to pay the invoice dated June 22nd, 2017. As Mr. Kaufman stated, the plaintiff filed their complaint on September 17th of 2017. I've got September 20th, 2017 in my records. All of the conduct that they used in their motion to base sanctions on all occurred prior to initiating litigation. So 915.14 just is not the proper tool for that. The proper remedy would be under OCGA section 13.611, which when a person seeks fees for pre-litigation conduct based on bad faith, stubborn litigiousness, and unnecessarily expanding litigation, that's what you use. While Inland denies that the conduct violates OCGA section 13.611, the alleged conduct is pre-litigation conduct, and if they can convince a jury that there's bad faith, then they have a remedy. In their motions, in the plaintiff's motions, they have argued that it wouldn't be fair to make them proceed under 13.611 because the fees get cut off at the time they file the complaint. That's just wrong. The 13.611 looks at the conduct that occurred before they filed the complaint, but they can still get all their fees from the time they filed their complaint going forward. So the proper remedy would be 13.611 based on the motion, not 915.14. When you look at what Inland did in this case, Inland did nothing in litigation to warrant fees under OCGA section 915.14. There are two standards for 915.14. There's Part A, which is a mandatory provision, and there's Part B, which is permissive or discretionary. Under Part A, it requires a complete absence of any justiciable issue of law or fact that it could not be reasonably believed a court would accept a claim. And what that means, the examples are that if a party asserted a legal defense that did not apply, such as the statute of limitations when the complaint was clearly filed within the statute, that would be an example of sanctions under A. Another example would be asserting a factual defense when your own witness contradicts the facts, such as if you claim that an injury was not caused by your actions, but the independent medical evaluation doctor that you hired said it did. A third example of sanctions that would be appropriate under 915.14a would be relying on a legal defense where controlling authority is against you and you have no reason to believe it could be reversed. The final example of where sanctions are appropriate under Part A is relying on a novel legal defense where there is no reasonable basis to believe that a court would accept it. When you look at the answer in Inland's conduct, there is nothing presented in it that justifies an award under the mandatory standard. Inland did not rely on inapplicable legal defenses. We asserted lack of actual authority. That is a legal defense that exists. We asserted lack of apparent authority. That's a legal defense that exists. The facts that were testified to by Jerry Staines, Mike Domina's manager, supported the defense. But Jerry Staines was adamant throughout that he never gave Mr. Domina authority to sign an agreement, and that he didn't know about the agreements until much further down the road, until they were first sent demand letters in 2018. Also, there is no controlling authority adverse to Inland's positions. Neither the Supreme Court of Georgia nor the Georgia Court of Appeals has ever issued precedent that a general manager has authority as a matter of law to bind his or her employer. Now, Inland is not asserting that this court doesn't have the authority to find that Mike Domina, as a general manager, had authority as a matter of law to sign it, but there's no precedent, nothing out there issued by the Supreme Court or Court of Appeals to let Inland know that that would not be accepted as a defense. And honestly, Judge LRB next door could come to a different decision and find that a general manager does not have authority as a matter of law. So there's nothing that Inland did based on the case law regarding Part A that would warrant or justify awarding fees. Now, Part B is the permissive statute, which is discretionary, and that allows the court to award fees when a party has interposed, has asserted a defense that lacks substantial justification, was interposed for delay, or a party unnecessarily expanded proceedings by other improper means. And lack substantial justification means substantially frivolous, substantially groundless, or substantially vexatious. In our case, Inland was substantially justified in asserting its defense. Jerry Staines, Mike Domina's supervisor, said he never gave him authority to enter into agreement with Top Quality Recruitment, and that he didn't even know about it until the demand letter that was eventually sent. Lorianne Jekyll, who worked for Top Quality Recruitment, stated that she did not rely on Mike Domina's title of general manager to find that he had authority. We were confronted with issues of impeachment. Mike Domina, who said he had authority from Jerry Staines, also after 30 days after he signed the agreement, wrote Top Quality Recruitment saying he needed a contract for corporate approval. Well, if he'd had approval from his superiors, why is he asking for another contract to be approved by the corporation? We presented legal issues of whether the contract could be performed in a year, which would implicate the statute of frauds and the equal dignity rule. We also had the legal issue of whether the contract was indefinite and therefore terminable at will, and terminated when Inland rejected plaintiff's candidate and hired someone else. There was also the issue of whether there was reasonable reliance on the part of Ms. Jekyll. All of these show that Inland was justified in its defense. The plaintiff's actions also confirm that Inland was substantially justified. When you look at the complaint, of the plaintiff, under count one, they didn't just proceed with actual authority, or just apparent authority. They also proceeded with quantum merit and unjust enrichment. If this was a case where it's obvious there was actual authority, there was no question, there would be no reason to have a much lengthier complaint. If they were certain that they couldn't lose on breach of contract, they wouldn't have added quantum merit or unjust enrichment. The plaintiff was hedging its best because there was uncertainty as to whether or not they could win going forward on just breach of contract and just actual authority. But Judge, and this is even more important, is that the plaintiff also ended up redrafting its contingency search agreement on May 17th of 2018. Clearly, the plaintiff recognized that there were problems with its contract and the possibility of enforcement. Otherwise, there wouldn't have been any reason to redraft that contract. Also, Judge, looking at this is important. Inland has not been substantially vexatious because it has cooperated with the plaintiff at every opportunity that presented itself. When Inland consented to take this case off of Judge Whitaker's September 2018 jury trial calendar at Mr. Kaufman's request because he said it was going to interfere with his campaign for the General Assembly in 2018. Inland consented to take Mr. Domina's deposition after the period this court set forth in its October 12, 2018 order, again at Mr. Kaufman's request, because it was going to interfere with his political campaign. And he also stated that if he won, it would interfere with him going through freshman legislator orientation. In addition, at Mr. Kaufman's request, Inland consented to use Mike Domina's deposition at trial instead of requiring his appearance in court, which was of no benefit to Inland. When Inland appealed and Mr. Kaufman filed a motion for supersedeas bond, we immediately called him and said, we'll pay $20,000, no problem. But he rejected that and wanted 23. We ended up going to court on that, and the court sided with Inland and set the supersedeas bond at 20,000. When this case was sent back to this court on remittitor, we cooperated with the plaintiff to expedite the release of the $20,000 from the court registry. When the plaintiff asked for interest, we promptly paid the interest as calculated by the plaintiff without any quibbling on it. And most recently, we consented to postponing this hearing so Mr. Kaufman could participate in Donald Trump's election litigation. Inland has cooperated and done nothing vexatious and tried to be a good defendant in this case and professional in every step that's presented itself. And this court also indicated during oral argument on the cross motions for summary judgment that it was giving serious consideration to the defense on the indefinite contract and agency at will. I think we're having a problem here, Judge.
I can hear you though.
Can you see us?
Okay.
Sorry, it just no.
It's on my iPhone, and we had a call coming in. Sorry.
I understand.
Sorry about all that, Judge. That's the same during the got thrown off here. During the hearing for the cross motion for summary judgment, this court stated that it was indicated that it was seriously considering our argument about the indefinite contract and whether it had been terminable at will.
I'm sorry, you said what contract?
Whether the contract had been terminable at will.
Terminable.
Finally, Judge, the sole basis that the plaintiff has given for fees under 915.14 on his motion is because it won in summary judgment. But the case law states that winning on a summary judgment or a trial without more does not entitle a plaintiff to OCJ section 915.14. That 915.14 doesn't change the rule that each party pays for their attorney's fees. The case of Hire versus Paxson in 1994 reported at 214 Georgia Appeals 552, 449 Southeastern 2nd, 120 is illustrative of that position. In that case, the appellant won on summary judgment and then requested for attorney's fees based on winning on summary judgment, and the court declined. They then appealed, and the Court of Appeals rejected their argument, instead stated that a prevailing party is not per force entitled to an award of attorney's fees under this statutory subsection. For these reasons, and for those stated in the briefs, Inland asked that this court deny the plaintiff's motion for fees under OCGA section 915.14. However, if this court is considering granting the plaintiff's motion, Inland requests an evidentiary hearing, which is our right, on the reasonableness and necessity of the fees requested, and an order requiring the plaintiff to allow it to inspect and copy the original handwritten time records, because plaintiff's attorney fee summary in its affidavit has numerous errors on its face. The plaintiff is asking this court to award fees for work that it didn't perform in this case. When you look at the fee summary that's attached to the affidavit, Mr. Coffin's asking for 3 hours for work performed on April 23rd, 2018 by ABK at $3.25 an hour for prep for mediation. However, there's never a mediation in this case. Mediation was never even scheduled in this case. Mr. Coffin's also asking for 2 hours for work performed on May 17th, 2018 by JC at $2.25 an hour to draft a new search agreement for plaintiff. And that is followed up with a request for 30 minutes for work performed on May 29th, 2018 by RJK at $520 an hour to review and revise the new search agreement.
I'm sorry, slow down a little bit, please. What was the last thing you said? By RJK and how much?
RJK at $520 an hour to review and revise the new search agreement. There is no legitimate reason why Inland should be requested by the plaintiff to be paying for the work to revise top quality recruitment's contingency search agreement. It had nothing to do with the litigation whatsoever. Mr. Kaufman is also asking for 0.4 hours for work performed on June 8th, 2018 by ABK at $3.25 an hour for a call with General Counsel and a conference with Enrique Ramos on June 8th, 2018, followed up by 0.1 hour for work performed on June 14th, 2018 by ABK at $3.25 an hour for legal research and a conference with Enrique Ramos regarding a California employment recruitment law. And then another 0.1 hours for work performed on June 15th, 2018 by ABK at $3.25 an hour for a conference with Enrique Ramos and a review of correspondence regarding a California salary. This case had nothing to do with California law, had nothing to do with the California salary. And Mr. Kaufman is either confusing work performed for another client with top quality recruitment work or confusing work for top quality recruitment on a different issue that's completely unrelated to our litigation. When you look at the billing summary, Mr. Kaufman also asked for pre-litigation fees. He's asking for work performed between July 19th, 2017 and the date they filed the complaint for working on demand letter, for phone calls and conferences, and drafted the complaint. And he's also asking for fees for a motion he lost. Again, we did have the motion to reopen the discovery period, which the court granted, and he wants fees for defending that, but they lost that motion. To touch on a couple of things that Mr. Kaufman brought up, the personnel files that were the subject of, or that were the subject of the hearing on the motion to compel. The motion to compel never had anything to do with the written motion to compel was only about the emails. It had nothing to do with personnel files which were redacted. When we got to court and we were discussing the emails, Mr. Kaufman then brought up the issue of the personnel files that were redacted. They had social security numbers taken out, dates of birth taken out, and different tax forms that were completed by those employees. These employees had nothing to do with the case. They were non-parties. And what we offered to do at that time was to turn over to the court. The court then turned over the redacted versions to Mr. Kaufman, but those personnel files were never used in the motion for summary judgment. They had nothing to do with the case and had no bearing and benefit to the plaintiff. The deposition, the reason why we asked to take the deposition after the fact is because Mr. Kaufman originally scheduled deposition, but then he got an affidavit, took away our ability to cross-examine Mr. Domina, and that's why we requested it. Although the order that you signed, and we were perfectly content with this, that to allow it to be done via telephone, but Mr. Kaufman didn't want that to use that option. The emails that Mr. Kaufman talks about for spoliation, none of those motions were used to get the motion for summary judgment granted, so they wouldn't be something that the court should consider. But in Mr. Domina's deposition, he stated that there were no email communication with Jerry Staines regarding authority or regarding the top quality recruitment contract. So there was no spoliation because there was nothing in the emails that was related to the case anyways. The final matter I want to touch on is that when you look at the billing summary that's attached to the affidavit, there is a incredible lack of specificity in it. And that's, again, another reason why we need to look at the original records. There's conference, call, conversation, but there's never anything telling us what was being talked about in any of those conferences or what was being talked about in any of those calls. And the fact that there are other errors on their face makes all of those questionable. And the only original business record is the one that's done at the time of that is completed. The billing summary was not done by somebody with knowledge of the events that are reflected on it because there were numerous entries from other attorneys. The billing summary was not done at or near the time the events were reflected on it because it was done months after the fact or years after the fact in preparation for this hearing. The only real record is the actual time record completed by the attorney because that's what was done by somebody with knowledge at or near the time of the events that were reflected on it. And if they don't have them, that's a real problem for them. I mean, we keep our billing records for at least 3 years. And I was drew up in four Drekel and Farnham, I think we kept them for even longer than that. For the reasons that we've stated here and in our brief, again, we request that this court dismiss or deny the motion for fees under 915.14. But if you are considering granting them, we request an evidentiary hearing so we can really probe the necessity and reasonableness of the fees. And we request an order to allow us to review the original records 30 days prior to court, so that way we can have an efficient hearing. Thank you.
Okay, let me ask you a couple of questions, if I may.
Sure.
Why isn't this the hearing that you seek? He's right there. You can ask him any questions that you like, and obviously you have already reviewed these in depth. I guess I'm just sort of wondering, is there authority that I'm missing for a specifically separate evidentiary hearing? Who else would you call, I guess?
Well, we would call an expert witness to testify as to whether or not they were reasonable. Also, in order to use a billing summary, you have to bring your original records with you to court and allow the opposing party to review them. And we've never seen the original records upon which they base their billing summary. The case law is clear that that's error for a court to proceed without providing a specific evidentiary hearing regarding the fees. And on this court's notice of hearing, it said that it would, let me read what the court wrote here, that it would be oral argument. It stated it was oral argument, but it didn't state it was an evidentiary hearing. So, and we had requested in our response an evidentiary hearing and in our reply an evidentiary hearing, but the notice always said just oral argument.
Sir, I'm sorry. You said some other hearing after evidentiary hearing?
The notice only specified oral argument. It didn't state that there'd be an opportunity as an evidentiary hearing. And it would be limited to 1 hour. To go through all these records, we're going to be way more than an hour. So based on what we got with the notice of motions hearing, there wasn't anything that told us that we could do, that this would be an evidentiary hearing, especially because we'd asked for an evidentiary hearing and we were told we were going to have an oral argument. I'm sorry, Judge, if we misunderstood the way the order was drafted.
Well, because I want to be completely fair about this. So let me push you a little bit on that. So what do you think we're doing today? Just decide threshold issue of whether.
Yeah, we thought this would solely be regarding whether or not there was behavior on Inland's part that would justify going forward with 915.14 sanctions. If the court decided that there'd be something to go forward with, then we'd have the evidentiary hearing. If the court found that there wasn't basis for 915.14 sanctions, then that would just end this matter here today.
Okay, that's fair. That's what I wanted to find out. And let me ask you one other question that I wrote down. The question of whether I think I hear you say that the bills submitted to the court by way of affidavit are not really business records.
Correct. That is a summary. There's a lot of litigation under 13611 and some under 915.14, and we reference it in our SIR reply for sure. I think we might have talked about it in our reply, but definitely our SIR reply, that the summary that's attached to the affidavit, that is not a business record. In fact, that was prepared for litigation. So that's the definition of not a business record. The Court of Appeals, the Supreme Court that have looked at this said that, and those cases do come before you have the change to track the federal rules of evidence. But those cases state that the only actual record, the business record, is the time entry that the attorney has completed, not even what was sent out to a client, because again, that is a summary of the business record, because the business record is what's made by somebody with knowledge of the events reflected on it, and it's made near the time of those events. A bill going to a client is a summary of the record because it's done by somebody who doesn't have knowledge of those events. Could be support staff, secretary, who knows who it was. And also it's performed not near the time of the events reflected on it. And the summary that's attached to the affidavit, that's even more so because it was done years down the road from the entries that are on it. So the only real business records are the actual handwritten time entries done by the attorneys. The case law also states that the only person who can testify as to the reasonableness of an individual entry is the one who made that entry, unless the attorney was literally elbow to elbow. It's not just some nice phrase. I mean, Mr. Kaufman would have to state that on every single of his entries by JC or RJK or everyone else, that he was actually with that attorney or that person when that was going on. It's not enough to just say you're elbow to elbow, but not actually working with a person on that matter to testify the reasonableness. You would then need to bring in the actual witness who did that time entry.
Let me just, let me push you on one thing, because I think clearly much older, but I think we have a similar background because you mentioned Drew Eckel. The person who taught me how to do the time entries was Jim McDonald. And I don't know if you ever practiced with Jim, but we took a pen and a long form provided by the firm, and we went down to 0.6. I mean, 0.1. It's 6-minute increments. I don't think there was ever anything less than a 0.1. I don't think that's how it's done now. I don't think there are lawyers sitting at their desk keeping handwritten time records.
Well, if they don't have handwritten time records, then they would at the very least have entries that they personally enter on the computer. I know that we still use the long form time entries, and the way I was taught, I was John Bruffy at Drew Eckel, and that, you know, when you put down phone conversation, you have to say what that conversation was about. And especially because we dealt with AIG, and if you didn't tell AIG what you were talking about with that particular person or what that conference is about, they wrote it off. In fact, I mean, I don't think you could even talk about conferences. Those were just, you know, written off right off the bat, because you should not have to bill for a conference with a partner. But there was a firm I worked with for a short period of time, and I was with Travelers for a while as well. And even where we didn't have our handwritten time entries, we were still expected to enter them into the computer. So and those individual things would be printed out and then converted into the bill. So if they don't have physical handwritten entries, then at the very least, they should be able to pull up through their timekeeping system what the individual attorneys wrote down. And what concerns me so much, and why we need to see what was actually written, not what was put down into a condensed version, is because they have asked for things that clearly didn't happen in this case, such as the California law issue. This case had nothing to do with California law, nothing to do with California. And this is after Mr. Kaufman swore to the court that those were true and accurate, yet they're clearly not true and accurate. He's talking about mediation, preparation for mediation. Never happened in this case. He's talking and he's trying to bill for redrafting his client's contingency search agreement. So something is not right with their records. And that's why we really want to go through and look what the attorneys who did them actually wrote. And that's why we want to cross-examine JC or RJK or whoever entered in to find out what was going on.
Okay. All right. Let me push you on a couple of other things. Number one, is a bill or is there any attorney-client privilege that attaches to an attorney's bill? For example, I get, not so much in the work that I'm doing now, but in family division, for example, I would get reams of bills redacted. because there continued to be a certain amount of privilege, and I may be getting off into a tangent, and forgive me if I am, but there continued to be a certain amount of privilege attached to what the lawyer and the attorney actually, I mean, the attorney and the client actually talked about. Do you see any distinction there?
In a family law case, I can understand why there would be, because you might have to talk about the psychological issues or issues of minor children. But in this case, that shouldn't be the case, because anything that they're asking for litigation involving inland, we should be able to see what they were talking about. I mean, if they said conference with and that's all redacted, then there's nothing to tell the court that that conference was related to a litigation matter as opposed to a California employment law matter. If they have a telephone conversation as redacted, then there's nothing that tells the court that it was regarding something that's necessary for litigation and wasn't involved some different matter for that client. So if they want,
there's one thing that's different, an attorney's oath. When the attorney swears that this was time spent, there may be errors, and that's why I'm not only more than happy, I'm obliged and more than willing to give you the opportunity to cross-examine Mr. Kaufman. But I'm just questioning how far back you get into an attorney's impressions, because at the end of the day, the matter is about what the client had to spend to prosecute this case, isn't it?
Judge, well, the case law states that this court has to do a detailed finding with specificity. And if you just say conference call, telephone call, conference, but you don't say what you're talking about, that doesn't meet the level of specificity required by the Court of Appeals for attorney's fees. And this is not easy, but this is not meant to be easy, because this is an abrogation of the common law rule that everybody pays their own fees.
I agree that 9-15-14, that everybody kind of wants to, I agree that it has probably been over broadly used. I absolutely agree with you there. I do question whether, I question what you want to see, because now if this case all of a sudden becomes about going into these law firms' billing systems, number one, where does that stop? I guess it's not really a floodgate argument, but where does that stop? And number two, if you want to cross-examine, pardon me, each person listed on the bill or the billing summary, is this going to take the same amount of time as the actual work in the case? And candidly, it's looking as if this is I don't know what this is prolonging the litigation in this case. Those were a lot of things, but if you want to speak to any of that.
And Judge, based on the affidavit, the only legitimate things that the plaintiff could ask for would be perhaps the complaint, their discovery, and the motion for summary judgment. Those are the only things that you could say were related to the answer. Everything else, all of the phone calls, all the conferences, there's not enough specificity to know what they were about, and if they're related to litigation, or if they're related to the California employment law issue, or some mediation that they had for some other matter. Okay,
but again, he's right there. That was the whole point.
Well, Judge, if we have to do an evidentiary hearing, you only gave us an hour.
Okay, that part, if you saw this as a two-pronged approach with the threshold issue of do we even want to get into it, the problem I have with that is, number one, I probably would not give you a ruling on that. I would just say, okay, we'll set it down for 2 hours or 3 hours or whatever you feel like you need for the cross-examination of Mr. Kaufman.
But we always did think this was going to be a two-pronged process when we saw your order.
Okay. I accept one lawyer's oath is good and the other lawyer's oath is good.
Well, Mr. Oliver here next to me can back up, because when I saw that, I asked him and he said, yeah, I think that's what they're doing. So we both came to that conclusion.
Okay. Okay. All right. Anything further before I turn it back over to Mr. Kaufman?
Well, Judge, I don't think this is appropriate under 915.14. It's definitely appropriate under 13.611. And that's the way this court should handle the attorney fee issue. It should simply be under 13.611, not 915.14. Because 915.14 is a punishment statute. It is to punish people. It affects a professional reputation. It is, we're talking a ton of money. I don't have $48,000. I mean, this is a severe punishment sanction. And I don't, and you're right. I have been seeing a lot of business attorneys throwing around 915.14 to convince their clients to sink tons of money, because they tell them, don't worry, you're going to get it all back because we can get fees under 915.14. And they're telling people a false bill of goods, because this is a punishment statute. 13.611 is what would really be the appropriate remedy for attorney's fees if a jury thought there was bad faith here. But getting into, Mr. Kaufman did talk about settlement negotiations, and I don't think that'd be appropriate for 915.14. It is definitely appropriate under 13.611 because it goes to bad faith and settlement litigiousness. But I do want to represent that Inland made very strong efforts to settle that were rejected. They were given a take it or leave it counter offer, counter demand by the plaintiff, and there was no negotiation on the part of the plaintiff.
Okay. I'm going to ask you a really unfair question.
Sure.
What if it was reversed? What if you were representing the plaintiff and the plaintiff came to you and said, I have this contract and they won't pay me? What would you have done?
Well, I mean, certainly you can file the lawsuit, but as I tell law students, that what we have as a system, our justice system is there to resolve disputes. It is based on principles of justice, so there's repeatable and predictable results, but ultimately it's about resolving claims. And how we resolve it is up to the parties. There's people can compromise and resolve this dispute that way, or sometimes they have to go to court and file a complaint. So, I mean, there's no problem with them filing a complaint, but sometimes that means that you're not going to get your attorney's fees. And they had the choice to settle early on for a reasonable amount, or they could go and do scorched earth litigation for 3 years. What was the point I was going to make? I mean, you have to make a choice. The contract, they could have protected themselves in their fee contract with their clients by putting attorney's fees in there that the loser, that in a dispute a loser would pay, but they chose not to do that. And because they chose not to do that, they have to live with the consequences of their actions. And contracts are always construed against the person who drafted them. So they drafted a contingent search agreement. They chose not to include an attorney fee provision, and then they chose to litigate this case to death when they could have gotten a very fair amount before months before a complaint was ever filed. But this is, again, now they're coming back and saying, well, that they want, their fees, but they want it under the punishment statute.
Okay. All right. Thank you. Mr. Kaufman?
Judge, if there was, well, first of all, I'd like to get out of the twilight zone, but if there was any case that deserved a 915.14 sanction, this is probably it. I mean, and I want to address a few things. So we mentioned about I think there was about 7 or 8 affirmative defenses that were just completely off the wall. Second of all, they've had ample opportunity to review these billing, they're not summaries, they're statements. I provided an affidavit on October 5th of 20, March 15th of 2019. And this is how it works. Most of the cases, the lawyer directly inputs the time as they go. Fox Rothschild uses in-tap time. application. It's actually on your cell phone that you can do it that way, or log right in. That's how most of the lawyers do it. Kaufman Foreman used an electronic billing program called ProLaw, where most of the lawyers put themselves in. So it's a little disingenuous to say, think that there's a mountain of hand notes that are out there. And frankly, I do usually keep some hand notes. I don't have them from that long ago to just I write them as I go, and then I input it. We have it inputted electronically, and that's that. These are the official records. I did work and review each and every one of them. I want to point out another thing that just so we're all clear. So in the affidavit that I placed on March 15, 2019, the fee number was $48,470. We went back on the proposed order and didn't bill. We took off $1,641 to make sure we were within the post-litigation time. And of course, if there was anything that was on this one client matter that had to do with anything other than the litigation, we would certainly yield to take that off. But we did go back and correct that from the timesheet versus what the proposed request was. So the idea that I was anything but straightforward and direct, which I pride myself on doing, is my duty as a lawyer, and I have great respect for this court. I would never do anything to the contrary, but we certainly adjusted it. If I missed something out of the 2.5 years of time records, because that's how long this monstrosity of the case lasted, then we certainly, if there's an error, we would yield to it. I want to direct the court's attention to, there's a case, Catherine Biner and Bottom Line Management Inc. versus Julie Dickerson and Dickerson and Associates Inc. It's August 18, 2004 case. The Westlaw site is 2004 Westlaw 5660975 Georgia Super. It was from Judge Manis, who addresses 91514 in particular, and basically this is a signpost order for this case. And she writes that she grants it in this section for 91514 because many of the plaintiff's claims were, in this case, it's the reverse, but many of the plaintiff's claims were substantially frivolous or groundless, and because counsel for plaintiffs unnecessarily expanded the litigation. The statute further defines, and I quote, lacks substantial justification, quote, as, quote, substantially frivolous, substantially groundless, or substantially vexatious. And that's what happened here. This thing was a $20,000 contract case that got dragged out in multiple states and for 2.5 years. And we don't have to go look at the time. You're right. I did ask for some to reset because I was running for the legislature. There's argument as to whether or not that is even just allowed by operational law for legislative leave, but we can put that on the side. That's a separate issue. But that had nothing to do with the over 120 filings that happened in this case as a result of mostly of their action. And the worst part is, and the reason I spent time on the pre-litigation, which I agree is not for the 91514, that's exactly why there is a request to be heard at the next jury trial for 13611 to deal with those, is but because they knew and the counsel knew and that this was a valid contract, they were part of it, they were officers of the company, and that is what made this behavior even more despicable here. And that this got dragged out. There was never a reasonable offer on the table. And then this thing got expanded and expanded and expanded with pie in the sky theories, such as what we've heard today, frankly. And here, if we look back to Judge Manis, she writes, in this particular case, this court finds that the fees are appropriate under 91514 B because many of plaintiffs' claims lack substantial justification and because counsel for plaintiffs unnecessarily expanded the scope of the proceedings with his conduct. And what's also interesting about this order is the judge addresses the fact that there was summary judgment granted. And while it's not dispositive, as I mentioned, that then fees should be awarded, but it is certainly indicative of the fact that the court should then examine if they should be. She writes, generally, if summary judgment is granted, this constitutes a determination that the claim lacks substantial justification, authorizing an award of fees. And she cites compare Seckinger versus Holtzendorf, HOLPZENDORF, 200 Georgia App 604, 1991. And she says the fact that summary judgment was awarded does not automatically entitle a moving party to fees. But however, in addition, fees may be authorized on claims where summary judgment was sought and denied if the trial judge could not, at the summary judgment stage, foresee facts authorizing the grant of attorney fees. citing Porter versus Felker, 261 Georgia 421, 1991. So here, the same thing. This was a clear summary judgment case. It was a binding contract, and now and they knew about it. They performed. In fact, when we look at the court's own order, which is the only law of the case, counsel's revisionist history is not part of the case, but the order of the case, the only facts in this case, and this is the court, Judge, that you wrote, Inland initially wanted to hire Mr. Morgan. However, the decision to hire Mr. Morgan was reversed when Mr. Staines realized Inland would owe Top Quality a recruitment fee upon hiring Mr. Morgan. So they went ahead and hired someone else. So that's the finding in this case, is that they knew that they had a fee, and instead they went another way. They didn't like the person they hired, and then they went back and hired Mr. Morgan anyway, knowing about it. And that's what put us into this mess. So you're right, that is part of the 13-611, which is why I have every confidence that the Fulton County jury is going to award those fees for that pre-litigation conduct. But what I'm here today is about the current, during the litigation since the filing of that lawsuit. But here, and that's why this Judge Mattis order is spot on point. This is exactly what happened. This was a clear-cut case. Now we're addressing the fact that my client took a 407 subsequent remedial measure to write a contract that was enforceable in Georgia. Mind you, they are for attorney's fees and had an arbitration provision and had California concerns. Has nothing to do with what happened here in this litigation and why we're here. And it shouldn't even be admissible because of 407. But that's certainly not, basically, you didn't have an attorney's fees provision, so we can drag you around the mud, make you litigate a case. And, our client had not only an interest in the $20,000 fee it earned, but also in the fact that it had other placements here needed to protect its reputation, to have that it was going to defend itself, that it shouldn't be taken advantage of and dragged through the mud, and that it would actually fight for its rights. And let's just think of the public policy here. You had a Canadian company looking to do business in Georgia, and now its vision of an American and Georgian judicial system is that you have to spend 2.5 years, go to the highest court in the land, because a large company decides that they're going to just play games and expand the scope and hope you go away. That has a public policy implication here, and frankly, it's just plain wrong. And that conduct is sanctionable, and that's why we have 9-15-14. These are clear under A and B. The court can pick either one or both. We humbly believe that 9-15-14A and B is what the court should find, and there is precedent on that case. They've had, since March 15th to 2019 to review these, they're not summaries, the actual billing records. There is a privilege component, which is why you don't list all those things. And since October 5th, 20, any lawyer doing this knows that this is how we do it. I stand in my place. I'm the partner in charge. I reviewed each and every one of these. I worked with every single lawyer on this, every lawyer that did any work at my direction. And not to mention, under the same Mattis case here, they talk about, as well as the Waffle House case, that I am the custodian of the record. I'm the corporate secretary of the company. I meet the 8036 business record exception, and I've stood here ready with both those affidavits to stand in my place and or be deposed.
Okay.
So with that, I have nothing for the court.
Okay. Let me just suggest this. Obviously, I was hoping that we would be through today. Are you suggesting, Mr. Kaufman, that there is something left in this case to go to a jury?
Well, the court did divide up because it was a 13-611, and the court did issue an order that said that it would be, those issues could be placed on the next available jury calendar. I would suggest that if my client's preference is that if we have this resolved right now, that we likely won't proceed any further, depending on what the court's award is. But the reality is, my client is out this much money, and this was on an hourly basis. It's not a contingency case. They've incurred those costs and expenses, and but there was a 13-611. In fact, it was also in your order under where you wrote further. The court finds that Mr. Morgan's base salary was $100,000. This court will conduct further proceeding to determine pursuant to OCGA 13-611.
Okay. Well, as I said, I was hoping we'd be through today, but I'll take it under advisement and I'll get something out just as soon as I can.
Thank you.
Okay.
All right, thank you, Judge.
Also, I do just want to say as we conclude, Mr. Oliver and Mr. Walker, it's frustrating for me because I'm there every day. We had been, our courthouse had been, the court was open, but we had been encouraged to work remotely and everybody. So when IT approached me about getting in there today, I told them that would be fine. So I'm sorry about that. I would never have cost anybody the joy of parking in our parking lot and coming up elevators if I could have prevented that. But thank you